In the case of Smyth and Northern Territory Treasury, an employee of the Treasury Department brought a complaint against another employee for sexual harassment and discrimination. She also brought the complaint against the Treasury Department in addition, alleging that they should be vicariously liable for the conduct. There are a series of events that occurred over a number of years, including unwanted touching in the workplace, inappropriate emails with sexual content, numerous phone calls, as well as Mr. Kerr, the employee, turning up at the individual's house on several occasions naked. Mr. Kerr was found liable for harassment and discrimination. Whilst it was found that he was a very touchy-feely person, the touching of Miss Smyth was unwelcome and had been witnessed by another employee who was cross-examined quite carefully in this matter about the conduct. Mr. Kerr himself admitted to a lot of the conduct, but stated that because Miss Smyth hadn't said that it was unwanted, that he thought it was fine. In this case, the Commission pointed out that just because an individual doesn't state that it's unwelcome doesn't mean that that's not the case, and certainly that's not the relevant test to be considered.
So what was also interesting was the employee brought the claim against the employer as well, and the Commission found that the employer was not vicariously liable for Mr. Kerr's conduct because they'd taken all necessary and reasonable steps to train their employees on anti-discrimination and harassment in the workplace. They had relevant policies. They'd been monitoring the correspondence between the two employees for a significant period of time. They'd attempted to mediate between them in the past, and the Commission found that all of these steps were reasonable, and there was nothing more that they could have done to prevent Mr. Kerr from sexually harassing the employee. So in this case, the employee, Mr. Kerr, was held responsible and the employer was not vicariously liable.
One thing that's quite surprising to me is that the Commission found that the incidents in the home had no connection to the workplace. That was based apparently on them having a form of personal relationship, so therefore the fact that they were Mr. Kerr ended up at Mrs. Smyth's house was not necessarily linked to the workplace. But the strange aspect of that is that it then, if that factual finding flows, it would give more credence in my mind to Mr. Kerr's assertion he didn't know that the conduct was unwelcome, because if they had the personal relationship, well then she probably could have said it. It seems more to me that it's got to be one or either. Either it's all a workplace issue, including the conduct at the home, which seems to be probably the better view, or alternatively they had a personal relationship and therefore it might have been hard for Mr. Kerr to know it was unwelcome.
I know with one of the instances of touching of Miss Smyth, there was a lot of evidence about Mr. Kerr was like that with all female staff, very touchy-feely, would touch people on the shoulders when he spoke to them or touch them on the arm. And that was in quite stark contrast, I think, to the emails, which were quite crude and sort of joking in nature, inappropriate and derogatory towards females, which I think were quite clearly harassment and discrimination, whereas I think some of the other issues it wasn't necessarily as clear, but it is certainly surprising that they've distinguished between some of the different conduct.